part of our syllabus. Yesterday we have discussed some of salient features of our Constitution of India. So in that syllabus, we have to discuss about some more concepts that are belong to the Constitution of India, India's salient features. As we discussed about historical background and also a preamble and also Constituent Assembly debates and some of members of the Constituent Assembly. So, as we discussed in yesterday's class, we have various salient features are there. As we discussed in yesterday's class, like written and lengthy constitution, rigid and flexible constitution, and some important features like sovereign, socialist, secular, democratic, and republic features of our Indian constitution, and parliamentary form of government, and federal structure with unitary bias. And also we have discussed about fundamental rights and also fundamental duties. So as part of our syllabus, we have to discuss about this important future. One is directive principles of state policy. As we concluded with yesterday's session with this topic only, directive principles of state policy. These principles is classified into three different parts. So one is liberal principles, one is socialist principles, and another one is Gandhian principles. In next class, we will discuss about entire directive principles of state policy. So here we have to know about these future of our Indian Constitution. So there is a small difference between fundamental rights and directive principles. As we discussed in yesterday's class, if someone violate our fundamental rights, we can approach court of law, means we can approach to the higher courts. So but here in directive, in case of these directive principles of state policy, we cannot approach any court of law. So this means these principles are not justiciable. Fundamental rights are justiciable. Already we discussed under the part 3 of our constitution. We have mentioned in 12 to article 12 to 35 articles about fundamental rights. In that area we have clearly says about protection of fundamental rights in article 32, that are 5 writs are there. These writs are main protector of our fundamental rights. The writs authority belongs to the from article 32 belongs to the Supreme Court. Article 226 belongs to the high courts in the states. So here these directive principles of state policy are different from the fundamental rights. So these are major indication of better public policy management by the both levels of the government. So when government wants to create any certain law or any certain provisions or schemes regarding to the minimum necessities of the people. So these principles indicates that government should provide basic needs like food, shelter, health facilities, education, drinking water, like that. Minimum necessities, minimum needs which are belongs to the common people. So in government mind, they have to mention these things in their policies. So these principles are indicators for the better policy making. So Indian Constitution is there for protection of basic livelihood of the common people in the world living in the country. So another one of important salient feature is independent judiciary. So as we discussed in first year classes, we have 3 different organs of government is there. One is executive, another one is first one is legislature, another one is executive, and third one is judiciary. So in that 3 divisions, 3 organs of the government, one important organ is judiciary. So this judiciary, according to the Indian Constitution, judiciary has been created as an independent authority without influence from the both levels of the government organs, like legislature or executive cannot enter into the activities of the judiciary system or cannot influence the judicial system entire India. So independent judiciary means this judiciary system is created for the protection of the people's rights. Means this is this is a protector of the individual rights, like we have right to freedom, we have right to speech, we have right to um, express our opinions on public policies or governments. In case anything, we have right. So these rights are uh, uh, means these rights are completely protected by the court of law. So that's what judiciary system has become an important organ of the this government sector. So that's what, according to the constitution, this independent judiciary has been created for the protection of both common people and also protection of our constitution of India. So the constitution is entirely created for the benefit of the common people who are living in the country. So that's what the constitution is, main protector of the individual rights and individual liberties of the people who are living in the country. So judiciary is the one of the important it is acting as a guardian of the constitution. So that's what our constitutional framers has been created for this as a independent body. So independent means there is no one can influence, no one can force to act such like this, such like uh, their wish. So that's what, no one can influence this independent judiciary system. So that's what our constitution of India has been made judiciary system as a independent organ from the, apart from the both government sectors. So one more important salient feature is single citizenship. Citizenship means we have who are living in the country has been recognized as a citizen with the residence or with some provisions are there. So the Constitution of India provides for Indians as a single citizenship. So you are living, if you are living in the Telangana, or if you are living in Andhra Pradesh or any other part of the country, we are called as a citizen of India. So in case of America, there is dual citizenship is there. So there are 51 states are there. So they are having as a citizen of United States of America and also citizen of their individual states. So here in our constitution, under part 2 of the constitution, from article 5 to article uh, from article 1 article 2, it discusses the issues relating to citizenship in India. So India is a federal structure. Already we discussed about federal structure. So we have been divided our authorities or powers between the both center and state. So provisions are divided as per the Constitution of India. But here the Constitution providing these principle, that is single citizenship. So as a result of this facility, citizens can move from one place to another. We can move from Hyderabad to Delhi, we can move from Hyderabad to Calcutta, or we can live anywhere in India, entire India. There is no restrictions. We have freedom to roam entire India. We can settle anywhere in India. So that's what Constitution providing this freedom. So if we are having citizenship, we can live entire India at any part of the India. So this is intended to promote national integration. So we have different cultures, we have different languages, we have different areas, we have different temperatures also, we different atmosphere also there, but we are calling as a citizen of India. So we can live in Rajasthan, we can live in Jammu Kashmir, we can live in Delhi, we can live in Tamil Nadu, Chennai, like that. We have right to settle anywhere in India. So we will discuss these right to freedom in next class, means next topic, fundamental rights. So another one more important salient feature of our Constitution of India is universal adult franchise. So we can simply call it as a right to vote. So the Constitution adopts this system of universal adult franchise and provided right to vote to all citizens above the 18 years. So who are living in the country, who are living in India, all adult citizens. So we have uh, we have been amended this right to vote age as a 18 years old. So all adult citizens, irrespective of class, irrespective of caste, irrespective of religion, race, gender, region, and there is no discrimination for providing this universal adult franchise. So all are eligible to vote after claiming their age as a 18 years. So Indian Constitution under Article 326 provides about this right. So universal adult franchise. So earlier the age for right to vote is 21 years, but later on the voting age has reduced 18 years through Constitutional Amendment Act of 61. So in 1988, this is reflecting the whole popular sovereignty in Indian citizens. So we have right to vote when we are getting age as 18 years. So this is the important salient feature of our Constitution of India. So, and also we are having one more important feature is emergency powers. So emergency powers means, as we discussed uh, about our constitution providing, in normal times we are having a general rule in entire both states and center. In case of emergency, in case of any attack on the country, or if any state fail to act as with majority of government, there will be central government or president can impose president rule under Article 356. In that time there are separate provisions are there how to rule in case of emergency, in case of lack of majoritarian government. At that time the entire administration goes to the under hands of the president of India. So about this emergency powers, we have been um, uh, placed on the part 18 of our Indian Constitution from Article 352 to 359 subclass A. So these provisions are provided for the better and regular constitutional machinery, because there is no there should be no lack of government or lack of administration for the sake of people's operations. So these extraordinary powers of the president can be classified broadly into three categories, as we discussed in emergencies. Firstly, emergency about if India participating in any war or some other country attacks on India, or internal disturbances, means any violences arised in India, at that time we will call it as a national emergency, Article 352. And the second one is under Article 356, we can call it as a constitutional emergency or president's rule. So in this case, emergency arising out of the failure of constitutional machinery in any one of the states, means if there is lack of majority in that case particular state, if government fails to prove their majority in assembly, At that time, the government will fell down with the principle of lack of majority in the house. So at that time, under Article 356, President can impose sorry that President rule under Article 356, that we will call it as a constitutional emergency. At that time, entire administration of that particular state goes to the under the hands of the central government in the name of President of India. And finally, and third one is, that is financial emergency. In this case, except provisions on financial emergency, all the provisions are utilized to protect the unity, integrity, and constitutional property of India. So, in this case, if we discuss about these three important emergency powers, we have been applied 3 times for national emergency, and more than 100 times president rule has been imposed in India in several parts. For financial emergency, not yet imposed any any time. So, and one more important feature is special safeguards for scheduled caste, scheduled tribes, and other backward classes and minorities and women. So the Constitution of India provides for special safeguards to various classes in general and oppressed classes in particular. So besides guarantees of fundamental rights, some of these sections are assured of reservation under protective discrimination clause in Article 15 and Article 16. So here the Constitution of India provides for the establishment of National Scheduled Caste Commission, National Scheduled Tribes Commission, National Commission for other backward classes, National Minorities Commission, and also National Commission for Women has been established for the special safeguards of their respective communities. So the Constitution of India provides these special provisions for the protection of these selected communities. So there are several constitutional commissions also there under the according to the Constitution of India, facilitates the arrangement of certain autonomous bodies or commissions such as Election Commission of India, Union Public Service Commission, Finance Commission, and Comptroller and Auditor General of India, and many other institutions also established under the respect of the Constitution of India. So these commissions function impartially and safeguard the national constitutional values through their functioning. So these organizations function non-partisan basis and check the excess of the ruling party. So some organizations like Election Commission of India, Union Public Service Commission, Finance Commissions are arranged in the Constitution itself. Other organizations like Central Information Commission, National Human Rights Commission, Central Vigilance Commission, etc., are arranged at later stage with special enactments. So, if government wants to create any such constitutional body or statutory bodies, they can amend Constitution and create that one. So we have one more important feature of our Constitution is judicial review. So as we discussed about the judiciary system, judiciary has been created as an independent body. Here, judicial review means the Indian judiciary has the power of judicial review in accordance with the provisions of the Constitution. Based on this judicial review, the Supreme Court and High Courts have the power to review the enactments. Enactments means in case of Lok Sabha or Rajya Sabha, in case of state assemblies made any enactments or policies, resolutions, and orders passed by them, the judiciary system has right to review these acts or policies. So by using this power, Indian Supreme Court has a separate authority over this judicial review system. In popular case, one of the important cases there in 1973, that is famous Keshavananda Bharati case. The Supreme Court delivered a verdict about the Parliament can amend the constitution, but they have to follow the basic structure of the our constitution. So this is popularly known as basic structure doctrine. It is understood that the supremacy of the constitution. So the parliament can change, can modify, or can amend the constitution, but they should not uh, mistake, or they should not go without following this basic structure doctrine. So as part of this basic structure principle, the Supreme Court observed that the Parliament can amend any part of the Constitution except the basic structure. So overall, we have almost 12 to 13 special salient features of the our Constitution of India. So in this topic, we have discussed about several features of the Constitution of India. So we are also having important topic is fundamental rights. So the Constitution of India, at the time of enactment, at the time of implementation of the Constitution of India, we have 7 fundamental rights. Before discussing about these fundamental rights, we have to know the historical background of the fundamental rights. So actually, rights have been the demands of individual liberty. It demands of individual freedom everywhere in all ages, because the good social life will not be possible without these rights. So the origin of the rights, the origin of the rights of the individuals is a mystery and antiquity. So in India, the demand for a Bill of Rights originating during the freedom struggle and the national movement. So as we discussed in first chapter in Indian national movement, we have observed, we have motivated from many revolutions entire the world. So in that case, in 1789, we have observed French Revolution. In 1776, American independence movement also we have observed, and in 1917 we have been observed an important glorious revolution, that is Russian Revolution, and we have adapted these rights from the movements. So the Indians desire for civil rights were implicate the formation of Indian National Congress in 1885. So a series of resolutions adopted by the Congress between 1917 and 1919 repeated the demand of civil rights and equality of status with Britishers. So further, many sessions went with this Indian National Congress, and also in implementation of Government of India Act 1935, many committees are there and reviewed the demand for these individual rights about Indians. So our rights bear the designation of fundamentals in the sense of they are likely to honored by all kinds of government and state, and not in the sense of fundamental rights. So these fundamental rights has been adopted from the American Constitution and kept under the Part 3 of Indian Constitution, which enumerates the fundamental rights are more elaborate than any other existing constitutions and cover a wide range of topics. So at the initial stages, when we are implementing our Constitution of India from the date of 26 January 1950, there are 7 fundamental rights are there in our Constitution under the Part 3 from Article 12 to 35. That are, one is the right to equality, and second one is right to freedom, and third one is right to against exploitation, and fourth one is right to freedom of religion, and fifth one is cultural and educational rights, and sixth one is right to property, and seventh one is the right to constitutional remedies. But the right to property, which is placed as a sixth right in list, that is abolished through the Constitutional Amendment Act of 44th in 1978 and kept as a legal right under the Article 300 subclass A. So now we are having only 6 fundamental rights are there in our constitution under the part 3. So this is the historical background of our fundamental rights. So if we have to know also about the important characteristics of fundamental rights, as we discussed the difference between the fundamental rights and directive principles of state policy. There are some differences are there na? Like that these fundamental rights are in nature there is a special protection from the our judicial system, that is we called it as a justiciable in nature. So fundamental rights are justiciable in nature, means they are protected by the judiciary against any violation. If government or if any individual violates our rights, we can approach the court of law, we can approach Supreme Court of India and also the High Court of India under Article 226. In case Supreme Court under Article 32, in case High Court under Article 226. So these articles empowers the courts to issue the writs, like as we discussed in yesterday's class. There are 5 writs are there. One is habeas corpus, and another one is mandamus, another one is prohibition, certiorari, and quo warranto. These 5 writs are there for the protection of fundamental rights when they are violated. So during the national emergency, Article 32 can be suspended. So, but some special provisions are there. At that time, these judiciary systems, which are Supreme Court and High Court, retains the power of issuing writs under the Article 32 and 226 respectively. So and also these fundamental rights makes use of 2 terms, citizen and person. So we have to know about the difference between citizen. So the constitution makes use of the 2 terms, this citizen and person, at different places in part 3, means fundamental rights are there in part 3. So some rights are given to the citizens and some others are available to all persons living in the country. For example, equality of opportunity in matters of public employment, or freedom of speech, freedom of assembly, freedom of expression of thought and opinion, right to movement, etc., are guaranteed to the citizens. And also, in the other hand, equality before law and its equal protection, rights against exploitation, freedom of religion, etc., are able to any person, whether Indian or foreigner. So here citizens means only citizens of India. Persons means who are living in India, whether he is Indian or foreigner. So that is the difference between citizen and person. And also these fundamental rights are not absolute, means the state can restrict the fundamental rights in the part of maintenance of peace and uh, safety in order to in the society during the period of national emergency under Article 352. According to the Article 359, the president can suspend all the fundamental rights except those mentioned in the Article 20 and 21. So in nature, the fundamental rights also divided as a in nature negative and positive method. So some of the fundamental rights are negative in character and some other are positive in nature. For example, Article 15, 17, and 18, certain others are negative injunctions. They impose restrictions on the authority of the state. Under Article 19, subclass 1, that provides 6 freedoms to the citizens. It positive in nature. Hence, the Indian Constitution provides both negative and positive rights. And also there is some restrictions are there on these fundamental rights, that is especially for the armed forces. The members of the armed forces such as police force, paramilitary forces, intelligence agencies have only restricted or abrogated application of these rights. So and one of important feature and characteristic is enforceability. Most of the fundamental rights are directly enforceable, but few of them require a law to be enforced. The law of right to education, an act of parliament of bonded labor and child labor, preventive detention laws, etc., are the few examples of enforceability of fundamental rights. So as part of our syllabus, if we see the classification of fundamental rights as divided into six, as we discussed, the one of the right from the list has been suspended, means deleted from the list of fundamental rights and kept as a statutory right, that is the right to property. So under article 31, the initial stage at the time of implementation of this constitution, we have been placed in article 31. After 44th constitutional amendment act in 1978, we have deleted from the fundamental rights list and kept as a statutory right or legal right as in 300 subclass A article. So here we have six fundamental rights are there. As part of this, we have to know about, we have discussed that the fundamental rights are placed from the article 12 to 35, but here we have mentioning about the right to equality from article 14. So article 12 and 13 says that according to article 12 means these tells about the definition of state, which is applicable in part 3 of fundamental rights. The state includes the government and parliament of India and the government and the legislature of each of the states and all local and other authorities within the territory of India are under the control of government of India. So article 12 says the definition of the state. So article 13 says about judicial review. So article 13 says about judicial review, means as we discussed the separate provision provided from the constitution of India to the independent judiciary, that is tells about article 13. So according to the right to equality, tells about the from the article 14 to 18. According to article 14 says that all are equal before law. So there is no discrimination, there is no special provisions in case of any differences, like in case of class, in case of rich poor, in case of religion, in case of gender or anything else. There is no discrimination. According to the constitution, the law provides equal protection to the all the citizens within the territory of India. So the constitution provides equal freedom and equality among the all the opportunities provided by the governments at the all levels. So for example, the president of India or the governors of states or the ambassadors or the foreign sovereigns are the given some special provisions or some limitations are there under this article 14. So according to article 15 says that there shall not be any discrimination among the citizens in the name of caste, religion, gender, place of birth, etc. However, this article imposes some limitations in order to promote the interest and well-being of women and children. So according to the right to equality, we have separate features from this article 15. So this right is intended to establish the Gandhian ideal of social equality. However, this does not prevent the state from making any special provision from women and children and socially and educationally backward classes of people, or for social scheduled caste and scheduled tribes. So, according to Article 16, ensures that equality of opportunity in matters of public employment. It is limited to employment or appointment of any offices under the state. So the state has power to make any provision or any provision for reservation of appointment under this article in favor of socially and educationally backward communities like SCs and STs are backward classes. So uh, there is uh, another one is uh, Article 17 says that the Constitution abolishes the untouchability and its practices in any form or is an offense. If anything happens in these grounds of untouchability or this system, it's called as an offense, and also it is punishable under the court of law. So in some cases, Gandhiji's struggle for the emancipation of the Harijans resulted in Article 17. So the abolition of untouchability removes a social disability and guarantees social equality among the citizens. So, and the last article from the right to equality is Article 18. Article 18 prohibits the state from the conferring any titles except a military academic distinction. So, in this case, according to the Article 18, the state shall not confer any title other than military academic distinctions to the citizens. Means the citizens should not accept titles from foreign states without the consent of Indian president or Indian government. So, however, the state can confer certain awards like Padma Shri, Padma Vibhushan, Bharat Ratna, Paramveer Chakra, Mahavir Chakra, etc., to military personnel basing on outstanding performance in social, educational, and military matters. So, this is all about right to equality from Article 14 to 18. So, another important right is right to freedom, that is under placed under Articles of 19 to 22. So, uh, the right to freedom is one of the most important fundamental rights, which constitutes a very essence of liberty. So, from Article 19 to 22 deal with right to freedom, they provide personal liberty too. So, under Article 19 says that according to Article 19 guarantees to all the citizens to the enjoyment of certain civil rights whilst they are free. The Constitution provides six freedoms to the citizens of India, like they are mentioned as a number one is right to freedom of speech and freedom of expression. We can right to speech anything, but they should not discriminate, or they should not belong to any violent method, or should not disturb others' freedom. So, according to the Article 19, we have right to freedom of speech and right to freedom of expression of our thoughts or opinions on governments or individuals. And one more important freedom is freedom of assembly. Freedom of assembly means we can assemble anywhere in India. Uh, uh, we can assemble with our colleagues or students or any individuals. So that is provided under Article 19. And also we have freedom of association, means we can uh, we can make any association, like we can create an employee association or student association. We can create any political association. We can create any organization. So that is also provided under this article 19. So, and also we have fourth freedom is freedom of movement. We can uh, we can start any movement against the any person or any government. We have right to move, right to move anywhere in India, and also we have right to right to move freely throughout the territory. So, as we discussed before, we have right to move from the anywhere from Kashmir to Kanyakumari, or we can move to Rajasthan, we can move to Pachim Bengal, we can move to northeastern states, we can move to Jammu Kashmir, like that. According to the under Article 19, subclass 1, under the fourth freedom of right to freedom, we have right to move freely throughout the territory of India. And another one is we have right to freedom of residence, as we discussed before, to reside or to settle in any part of the territory of India. We can, as Constitution providing this facility to the citizens of India who as recognized as citizen of India can reside anywhere in India. We can settle, we can build our house in any part of the India in entire 29 states. So that is provided under the Article 19. And also we have sixth freedom, that is we have right to practice any profession and or carry on any occupation or trade or business. So that means we have right to work as our wish. So we have right to freedom of profession. So these six freedoms has been provided under the Article 19. So the state may impose some of reasonable restrictions on the exercise of three rights of the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign affairs or foreign states, public order, defense or morality, freedom of court or information, etc. These rights are only applicable to the citizens of India. So, as we discussed, there is a difference between citizen and person. Citizens, those who are belong to the Indian connection interrupted. So, only these freedoms are provided by the Constitution of India only to the citizens of India. So, the right to freedom is subject to many reasonable restrictions, as we discussed in case of different various reasons are there, like sovereignty or integrity of India, public order, contempt of court, like other issues. So, according to Article 20, no person shall be convicted of any offense except for the violation of law in force at the time of committing the offense. No one shall be sentenced to punishment greater than provided by such law at the time. So no one shall be arrested and punished for the same offenses more than once, which means it lays down that no one shall convinced of an offense except of violation of law in force at the time of commission of such act. And also no person shall be prosecuted and punished for the same offense more than once. So according to the Article 20, no person accused of any offense shall be compelled to be witness against himself. So Article 21 says that uh, 21 prescribed that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The court interpreted the phrase procedure established by law. The word law means a positive or state made law and not a law arising out of rules of natural justice. So, according to Article 21 says that there is protection of life and personal liberty from the Constitution of India. So, according to it, no person shall be deprived of his life and liberty except according to the procedure established by the law. So, according to Article 22 says that it is deals with protection against arbitrary arrest and detention in certain cases. According to this Article 22, no person who is arrested shall be detained in custody without being informed. So he shall have right to consult or right to be defended by a legal practitioner of his choice. So he must be produced before the nearest magistrate within the period of 24 hours of his arrest. That will say about habeas corpus writ. So we will discuss it in under Article 32. So he cannot be detained in custody beyond 24 hours. So under this article, some are applicable to any person who is arrested under or detained under PD Act. PD Act means Preventive Detention Act. So the Parliament and state legislature has the power to pass preventive detention acts to arrest or detain or imprison any person without trial. If someone arrested under this act, there is no need to produce before the nearest magistrate. So under this article, many acts were passed like Maintenance of Internal Security Act and also Conservation of Foreign Exchanges, Prevention of Smuggling Act, National Security Act by the Indian Parliament. In order to save the country from the terrorists and anti-social elements, these acts has been made by the Parliament of India. So from time to time, some acts have been made to prevent this motto. So it may be pointed out safely that the arrangement of preventive detention is a crisis provisions in the interest and national integration. And we have one more right, that is third one is right against exploitation. So this right has been uh, explained from the article 23 and 24. According to article 23 says that it is prohibits traffic in human beings, means human trafficking or all sorts of inhuman acts like sale and purchase of human beings and similar other forms of inhuman acts. So this article prohibits bonded labor. However, this article is not absolute. For example, the state can impose compulsory services for public purpose. In this regard, the state shall not make any discrimination among citizens on the grounds of any religion, any race, any caste, any class, any creed, etc. So according to the article 23 of this right against exploitation means that traffic in human beings are begging of other such forced labor are forbidden and declares to be offenses. So according to the article 24, the children below 14 years, the age shall not be employed to any work or any factory or any mining company or any mining factory are engaged in any hazardous employment. So at the time of this age, the children must be in the schools only. According to our constitution provides, this article is to protect the children from exploitations, which is very dangerous to their health. It eats away their tender infancy. So even though the government of India has passed many legislations for the abolition of child labor, the children are still working as a child laborers in many factories, many mining projects, and some other places. So that's what the government, the parliament has made an act of Right to Education Act must be implemented with true spirit, so that the children could enjoy their childhood with the study and play. And as part of our fundamental rights, we have one more important right, that is right to religion. So the fourth right is right to religion, that is explained under Article 25 to 28. So the right to religion contains a major ideals of preamble of the constitution, which declares India as a secular state. As we discussed, secular means there is no separate uh, religion, or there is no official religion for the state. So India has providing, according to the constitution, all religions are same. There is no special treatment, any special religion. So all the religions are um, basically treated as same. So there is no special provisions are provided any particular religion. So as per right to religion, there is no special provisions. It includes freedom of conscience and of professing, preaching, and propagating any religion subject to public order. So every religious uh, denominations can establish and maintain institutions. Like every freedom of religion is basically provided from these articles. So according to right to religion, we have said that India as a secular state. So here in our fundamental rights, Article 25 says that all persons are entitled to profess, practice, propagate any religion according to their choice. Means if you want to adopt any religion, you can adopt. You can, if you want to change religion from the another religion, you have right to change your religion too. So if you want to propagate, or if you want to uh, change your religion according to 25 article, you have right to change or follow the religion according to your choice. So but this freedom is subject to public order or morality and health. The state provides religious freedom to the people. The government does not recognize any religion officially. So that means that is tells about the meaning of secular. So according to Article 26 says that upon the religious groups the freedom to manage religious affairs. So subject to public order or morality and health, they have right to manage their own affairs in matters of religion. And also Article 27 says that states shall not impose or collect taxes from individuals purely on religious basis. So the state should not collect or impose taxes on the benefit of any particular religion. So according to Article 28 says that 28 bans religious instructions in educational institutions wholly or partly which receive the state aid. So in entire India, who which school or which any educational institution are funded by the government has to follow this Article 28. So this 28 article says that bans of religious instructions in educational institutions. So this is the right to religion. And one more important right is fifth one is cultural and educational rights. So these fundamental rights is explained in Article 29 and 30. So India is a country with many languages, religions, and traditions. As we discussed, we are following the principle of university in unity in diversity. Means we have different cultures are there, different religions are there, different traditions, languages are there, but we are maintaining as a Indians. So we are following that principles. So it is necessary to protect the interest of minorities, cultural, educational rights for stand for this motto. So, according to Article 29, says that Indian citizens shall have to have the right to develop their language, culture, and scripts. According to Article 30, that all the minorities shall have right to establish and maintain educational institutions, so of their choice to develop their script, language, religion, etc. So they may have their own governing bodies. They are entitled to have the right to admit the students to their institutions. So one more important right is right to constitutional remedies. The last one is sixth fundamental right is right to constitutional remedies under Article 32. As we discussed, this is the important article and important right, fundamental right of the Indian Constitution. So, right to constitutional remedies is the one of the major important act, because um, because these fundamental right is the main protector of entire fundamental rights. So Dr. Ambedkar says that it is the heart of the constitution. The article 32 is the heart of the constitution. So there is no meaning if there is no guarantee of fundamental rights. That's what article 32 provides. These five writs are there to protect the fundamental rights of the individuals. So the Supreme Court of India under Article 32 and High Court of every state under Article 226 provides these various five writs like habeas corpus, mandamus, certiorari, quo warranto, prohibition. So these five writs are there for the protect of fundamental rights when they are violated or threatened by the any private person or any public organization or any government. So it may be said that the power of issuing writs under the jurisdiction of both Supreme Court and High Court. Habeas corpus means the have the body, means the writ is regarded as the oldest one. Writ is issued by the court in case no person shall be deprived of his life or and personal liberty except according in procedure established by law. So in case someone arrested in any threat or any case, they have to produce nearest magistrate before within the 24 hours of the arresting time. So the court examines the grounds of confinement and sets the arrested person free if he is unlawfully detained. The mandamus writ means command. This is also issued to the public officials to do his duty which he failed to discharge. So the mandamus cannot be issued against the person. So this is completely for the public officials, means those who are working under the government sector. And another one is certiorari. Certiorari means the superior court to an inferior court if latter exercises the power beyond its jurisdictions, means the higher court can issue order to the lower courts. Because of this writ, there is protection to the fundamental rights of the citizens. So in nature, in character, this writ is a supervisory in character. This writ cannot granted against personal, any private person or any private association. And another one is prohibition. This writ of prohibition is issued by the higher courts like Supreme Court and High Court to the lower courts. So the certiorari and prohibitions are look like same, but there is a small difference. So this main objective of this writ is a place to inferior court or authority within their limitations. So this writ of certiorari is issued after the completion of the proceedings. And another one is quo warranto. Quo warranto means the objective of this writ is terminate the person from the office which he is unauthorized and not entitled to hold the post. So these five writs are important for the protection of fundamental rights. So as part of our syllabus, we have discussed in today's class fundamental rights. In tomorrow's class, we are going to discuss about the fundamental duties and directive principles of state policy. Thank you for your participation. Is there any doubts from this chapter? You may ask.
సార్ రేపు క్లాస్ ఉందా సార్?
రేపు లేదమ్మా, మళ్ళీ నెక్స్ట్
Next week.
సాటర్డే సండే.
ఓకే సార్.
సేమ్ మనకు యాజ్ పర్ షెడ్యూల్ ఎవ్రీ సాటర్డే సండే. లాస్ట్ వచ్చేసి 5th and 6th మార్చ్ ఉన్నట్టుంది. మొత్తం 10 క్లాసులు మనకు అలాట్ చేశారు.
ఓకే సార్.
సార్ సమ్ డౌట్ సార్.
చెప్పండి
సార్. ఇంకా మాకు సెకండ్ సెమిస్టర్ జరగలేదు, థర్డ్ సెమిస్టర్ ఆన్లైన్ క్లాస్ జరుగుతుంది. యు నో అబౌట్ సంథింగ్?
అవును, అయితే ఇవి మనకు కరోనా ఎఫెక్ట్ తోటి మనకి ఇట్లా డిలే నడుస్తుంది కదా. సో మీరు నెక్స్ట్ థర్డ్ సెమ్ కి కోసమే ఆఫ్లైన్ క్లాసెస్ జరపడం వీలు కాక ఆన్లైన్ లో క్లాసెస్ అవుతున్నాయి.
అంటే ఇప్పుడు మనకు పాసిబిలిటీ ఉందా సార్ సెకండ్ సెమ్ జరగడం?
సెకండ్ సెమ్ జరుగుతుంది. మీకు 1-2 days బిఫోర్ అడ్మిట్ కార్డు వెబ్సైట్ లో అప్లోడ్ చేస్తారు.
ఓకే సార్. ఇప్పుడు మీరు థర్డ్ సెమిస్టర్ జరుగుతున్నారు, మాకు ఇంకా అయితే మెటీరియల్స్ ఏం అందలేదు.
దేని థర్డ్ సెమ్?
అవునండి.
మీరు హైదరాబాద్ కు చెందిన వాళ్ళైతే మీరు యూనివర్సిటీకి వెళ్ళి తీసుకోవచ్చు బుక్స్.
సార్ మేము ఆన్లైన్ లాగిన్ చేసాం అనమాట, వాళ్ళకి సబ్మిట్ చేసాము సెమిస్టర్ మెటీరియల్ డౌన్లోడ్ చేసుకోమనేసి. కానీ వాళ్ళు చెప్పారు మేము మీకు పోస్ట్ ద్వారా పంపిస్తామని, ఇంకా పంపించలేదు వాళ్ళు.
పంపించకపోతే ఏంటంటే మీకు టైం ఉంటే కనుక మీరు జూబ్లీ హిల్స్ లో మన యూనివర్సిటీకి వెళ్ళి అక్కడ మీ ట్యూషన్ ఫీజు పేమెంట్ రిసిప్ట్ ఉంటుంది కదా, అది చూపిస్తే వాళ్ళు మీకు బుక్స్ ఇస్తారు.
ఓకే సార్. ఓకే సార్.
మీరు ట్యూషన్ ఫీజు కడతారు కదా
సార్, మేము ఆంధ్రాలో ఉన్నాము. అది మేము
అయితే మీకు స్టడీ సెంటర్ లో అప్రోచ్ కండి.
అవును సార్, స్టడీ సెంటర్ అప్రోచ్ అయితే వాళ్ళు అన్నారు మా దగ్గర ఇంకా ఏం రాలేదని, మీ టెస్ట్ పేపర్స్ ఫాలో అవ్వాలని చెప్తున్నారు.
ఓకే ఓకే.
హైదరాబాద్ ఆల్రెడీ ఆఫ్లైన్ క్లాస్ స్టార్ట్ అయినప్పుడే అడిగాం సార్. ఆఫ్లైన్ క్లాస్ స్టార్ట్ అయినప్పుడు అడిగితే కూడా వాళ్ళు మాకు రాలేదు, మీరు హెడ్ ఆఫీస్ కి కనుక్కోండి అన్నారు. సో మేము అక్కడికి పంపిస్తామన్నా, మా రిలేటివ్స్ ఉన్నారు పంపిస్తామన్నా అక్కడ ఇవ్వరు అంటారు. అసలు మెటీరియల్ లేక చాలా ఇబ్బంది అయిపోతుంది సార్.
మీరు ఎవరన్నా పంపించవచ్చు. మీ ట్యూషన్ ఫీజు రిసిప్ట్ ఉంటది కదా మేడం, దాన్ని వాళ్ళకు ఇచ్చి పంపిస్తే వాళ్ళు అక్కడ గోడౌన్ ఉంటుంది బుక్స్ ది, వాళ్ళ రిసిప్ట్ చూసి బుక్స్
ఇట్లా మా రిసిప్ట్ అవన్నీ ఇచ్చి పంపిస్తామంటే, సో అది పాసిబిలిటీ కాదు, మీ స్టడీ సెంటర్ లోనే తీసుకోవాలంటున్నారు సార్ వాళ్ళు కాల్ చేసి అడిగితే.
అయితే మీరు స్టడీ సెంటర్ లో బుక్స్ లేనప్పుడు మీరు అడగొచ్చు వాళ్ళని.
ఓకే సార్. వాళ్ళు
ఎందుకంటే ఎగ్జామ్స్ ఎలాగో
ఎప్పుడు పంపిస్తారంటే అవన్నీ మాకు తెలీదు, మేము అది ఎప్పుడు పడుతుందో కూడా తెలియదు అని మెయిన్ హెడ్ క్వార్టర్స్ వాళ్ళు అలాగే సమాధానం చెప్తున్నారు సార్.
సార్ యాక్చువల్లీగా ఫస్ట్ సెమ్ కి అయితే మాకు జస్ట్ ఒక 10 days 15 days లో ఎగ్జామ్ అంటే అప్పుడు మాకు ఇచ్చారు బుక్స్.
స్టడీ సెంటర్ లోనే ఇచ్చారా?
అవును సార్. మేము టెస్ట్ పేపర్లు కూడా మేము తీసుకొని స్టడీ చేస్తే కూడా మనకు దాంట్లో వచ్చే చాప్టర్స్ యూనిట్స్ కరెక్ట్ గా ఉండాలంటే దాన్ని చూస్తే మనం చేసుకోవాలి.
చూస్తేనే తెలుస్తుంది.
అవును సార్.
దాంతో పాటు బుక్స్ కూడా కొన్ని ఇప్పుడు బయట అదర్ టెస్ట్ పేపర్స్ లో చదివినట్టు కాకుండా కొంచెం టెక్స్ట్ బుక్ ఓరియంటెడ్ లోనే బిట్స్ ఇస్తున్నారు సార్.
అవును. కంప్లీట్ గా మన బుక్కే ఫాలో కావాల్సి ఉంటది.
అవును సార్. మాకు అది టైం టు టైం ప్రొడ్యూస్ చేస్తే సబ్మిట్ చేస్తే మాకు అందితే మేము చదువుకోగలుగుతాము, ఈజీగా ఏదైనా కొంచెం స్కోర్ చేయగలుగుతాం సార్.
మీరు మళ్ళొకసారి మీరు ఈ రోజు సండేనే కదా, మీరు మళ్ళొకసారి స్టడీ సెంటర్ కి కాల్ చేసి అడగండి బుక్స్ పరిస్థితి ఏంది. ఇప్పుడు మీకు కావాల్సిన సెకండ్ సెమ్ థర్డ్ సెమ్?
ఇప్పుడు మాకు థర్డ్ సెమ్ కావాలి సార్.
థర్డ్ సెమ్ అంటే మేబీ యూనివర్సిటీ పంపిస్తుండొచ్చు. ఎందుకైనా మంచిది ఒకసారి మీరు స్టడీ సెంటర్ ని అప్రోచ్ కండి, కాల్ చేసి అడగండి. ఎందుకంటే ఇప్పుడు థర్డ్ సెమ్ ఎగ్జామ్స్ షెడ్యూల్ ఏం కాలేదు కదా, మీరు సెకండ్ సెమ్ కి అపియర్ కాబోతున్నారు కదా.
అవును సార్.
సో దానికి టైం ఉన్నది కాబట్టి మేబీ యూనివర్సిటీ మీకు పంపిస్తుండొచ్చు. ఎందుకైనా మంచిది ఒకసారి మీకు
దగ్గర మెటీరియల్ ఉండి మీరు చెప్పేది చూస్తూ ఉంటే కొంచెం మాకు బాగుంటది కదా సార్. కొన్ని టెస్ట్ పేపర్స్ లో డిఫరెంట్ కాన్సెప్ట్ ఉంటుంది, అసలు మీరు చెప్పేదానికి వాటికి కొన్ని పాయింట్స్ మ్యాచ్ అవ్వవు, అర్థం కాకుండా అలా కాకుండా
అయితే ఒక పని చేయండి, మీకు
పాయింట్స్ నోట్ చేసుకుంటే ఆన్సర్ రాయడానికి మాకు ఈజీగా ఉంటుంది కదా సార్.
మీకు కావాలంటే ఈ థర్డ్ సెమ్ ది నేను పీడిఎఫ్ పంపగలుగుతా.
పంపించండి సార్. ఏదో మీకు ఓకే సార్, షూర్.
థర్డ్ సెమ్ అయితే నేను పీడిఎఫ్ నా దగ్గర ఉంది, నేను పంపగలుగుతా. నేను చాట్ లో నా నెంబర్ పెడుతున్నా, దానికి మీరు మెసేజ్ పెట్టండి, నేను పీడిఎఫ్ ఫార్వర్డ్ చేస్తా.
పెడతారా సార్? ఇప్పుడు
పెట్టేసిన
నంబర్
పెట్టేసిన చూడండి. 9030.
జస్ట్
మీరు దానికి మెసేజ్ పెట్టండి. నేను మీకు
లాగౌట్ అయిపోతే వాళ్ళు ఇంకా
794.
క్యాన్సిల్ చేసేస్తున్నారు సార్.
మీకు లాస్ట్ వరకు అయినా నేను ఉంటా, అవైలబుల్ ఉంటాయి. ఇంకా మనకు 6 క్లాసులు ఉన్నాయి కదా.
345.
మీరు దానికి మెసేజ్ పెట్టండి, మీకు పీడిఎఫ్ ఫార్వర్డ్ చేస్తాను. మీరు బుక్ రాకున్నా కూడా మీరు చదువుకోవచ్చు.
సార్ మనకి ఇప్పుడు దీనికి సంబంధించిన ఏదైనా ఇంపార్టెంట్ క్వశ్చన్స్ ఏమైనా ఇవ్వగలుగుతారా సార్?
అవి లాస్ట్ వరకు చూద్దాం, టైం
థ్యాంక్ యూ సార్.
ఓకే, థ్యాంక్ యూ ఫర్ యువర్ పార్టిసిపేషన్.
చాప్టర్ ఇప్పుడు ఏ చాప్టర్ జరుగుతుందో ఆ చాప్టర్ కి
మీరు ఒకసారి చూసుకుంటే మీకు కూడా ఈజీగా ఉంటుంది, అర్థం కాదు.
అవును సార్.
మీకు ఈజీగా అర్థమవుతుంది. ఇప్పుడు నేను చెప్పిన తర్వాత చదువుకున్నా, మీరు చదువుకొని వచ్చి క్లాస్ కున్నా ఈజీ టు అండర్స్టాండ్ అన్నట్టు.
అవును సార్, మీరు చెప్తున్న
ఎంత చెప్పినా వన్ వే టీచింగ్ అంటే కూడా మీకు కాన్సెప్ట్ కొంచెం ఐడియా ఉన్నా యూ కెన్ రిమైండ్.
అవును సార్, ఇప్పుడు మీరు చెప్పిన వచ్చి ఫండమెంటల్స్ రైట్స్ వచ్చి చాలా బాగా అర్థమైంది సార్.
ఓకే,
అది మనం కొంచెం టెక్స్ట్ బుక్ అని మీరు
ఉంటే ఇంకా ఈజీగా ఉంటది, గుర్తుంటది రేపు మీరు ఎగ్జామ్ లో రాయడానికి కూడా. నేను ఫార్వర్డ్ చేస్తాను, మీరు దానికి మెసేజ్ పెట్టండి, నేను ఈ బుక్ కు సంబంధించిన పీడిఎఫ్ ఫార్వర్డ్ చేస్తాను.
థ్యాంక్ యూ సార్. సార్ ఈమెయిల్ పెట్టాలా, వాట్సాప్ నంబర్ పెట్టాలా?
వాట్సాప్ లో పెట్టండి.
సరే సార్, ఇది వాట్సాప్ లో ఉన్నారు మీరు ఈ నెంబర్ సార్?
ఉన్నది, ఇదే నెంబర్ ఉంది.
థ్యాంక్ యూ సార్. థ్యాంక్ యూ ఫర్.
ఓకే, థ్యాంక్ యూ
సార్. యాక్చువల్లీ క్లాస్ అవ్వగానే కొన్ని టెస్ట్ పేపర్స్ లో ఎక్స్ట్రా క్వశ్చన్స్ ఇస్తున్నారు సార్. మాకు ఆ క్వశ్చన్స్ కొంచెం చెప్తే మాకు ఇంకా మీరు నెక్స్ట్ టాపిక్ చెప్పేటప్పటికి మేము ఈ టాపిక్ చదివేసుకుంటాం సార్.
ఓకే, నేను ఇది పంపిస్తా కదా, మనది ఈజీగానే ఉంటది కంపేర్ టు అదర్. మనది ఈజీగానే ఉంటది చదువుకోవడానికి. నేను పీడిఎఫ్ పంపుతానులేండి.
ఓకే సార్.
థ్యాంక్ యూ సార్.
ఓకే, థ్యాంక్ యూ ఫర్ యువర్ పార్టిసిపేషన్.
నెంబర్ కి కాల్ చేసి అడగచ్చా సార్?
అడగొచ్చు.
ఓకే సార్, మీ ఫ్రీ టైమ్ లో మెసేజ్ పెట్టినా మీరు రిప్లై ఇస్తారా?
ఇస్తాను.
ఓకే సార్, థ్యాంక్ యూ వెరీ మచ్ సార్.
ఓకే, థ్యాంక్ యూ ఫర్ యువర్ పార్టిసిపేషన్. నేను సెషన్ కన్క్లూడ్ చేస్తున్నా, మళ్ళీ మీకు నెక్స్ట్ క్లాస్ ఉంటది కదా.
ఓకే సార్, థ్యాంక్ యూ సార్.
ఓకే, థ్యాంక్ యూ ఆల్.